Employers, I think, just wanted the cases to go away and were more inclined to settle. We're back at the sort of number of normal employment cases. I would say 6 employment cases is probably about typical. Young versus UPS, this was about the pregnant woman who worked for UPS. That case got the most attention, and the SLC filed an amicus brief actually in one of the cases. Like I said, I think, that was a good sign for the economy. And the police cases docket was as big as ever. The court usually takes somewhere between 5 and 10 police cases. This term it took about 10. And in a docket of 70 cases, that's pretty significant. I'll talk about a few of them, but not many, because there were so many of them. So invariably, I must start with the 3 big cases. It's arguable whether there are really 2 or 3, but I think it's fair to say there were 3. So what do these terms have in common? I have to say John sort of tipped you off a little bit about this. Jiggery-pokery, which is actually a real phrase. Pure applesauce, and I have to admit my favorite, I would hide my head in a bag. These are Justice Scalia-isms. These are just some of the insults he was hurtling at his sometimes liberal and sometimes conservative colleagues on the court. If you're interested in these phrases and would like to be insulted yourself by one of them, you can Google Justice Scalia insult generator. Type in your name, and maybe you'll get jiggery-pokery or pure applesauce. Or he'd rather hide his head in a bag than interact with you. I'm actually serious about that. You can have some real fun with this Supreme Court term. So first, a few words about the same-sex marriage case. It was 5-4, and it was written by Justice Kennedy. The opinion was poetic, if not dramatic. I've just been married 5 years, and it was about a month from my 5-year anniversary after I read that. I read his opinion, and putting my feelings about same-sex marriage completely aside, I don't think I'd ever felt as proud to be married since the day I got married. If you have some doubts about the institution of marriage, doubt them no longer. Read Justice Kennedy's opinion. I mean, it's practically a tearjerker. But beyond the sort of poeticism of the decision, he did have some legal reasons in it. I mean, some might say some more than others. I might see them as legal reasons more than others. The basic bottom line of the opinion was that marriage is a fundamental right, and that 2 people should be able to decide if they want to engage in that institution. He looks at the concept of individual autonomy, this institution being more important than any other institution, that it safeguards children and families. And perhaps what's interesting, de Tocqueville hasn't been around for over a century, but people still sort of turn to him as this great commentator on American culture. And he said that marriage was the cornerstone of American culture and more important to any other culture than he'd ever seen before. And that was also one of Justice Kennedy's reasons. Now, from a more of a legal nerd perspective, for those of you who are attorneys in the room, what was interesting was the analysis focused on fundamental rights rather than a straight equal protection analysis. Why does that matter? When you talk about a straight equal protection analysis, you're talking about strict scrutiny, intermediate scrutiny, lower scrutiny. And why that's important is if the court would have focused on that, that would have determined how gay rights would be perceived in later cases. Justice Kennedy, I think, wanted to avoid that. He wanted to not tip his hand. He wanted to leave that open for future courts. So he focused on fundamental rights. The problem with focusing on that is, of course, if you look at the Constitution, there's no talk of fundamental rights, privacy, dignity or liberty or any of the other terms that he likes to use. But there is some merit to it. I mean, the sort of quintessential fundamental rights case came out of Loving versus Virginia, which is, of course, the case involving a white and black couple marrying. Now, what's gotten perhaps undue attention about this case is the fact that Justice Kennedy's opinion, he wrote for himself and the liberal justices, including 3 unmarried female justices. And as I was saying, it was such a celebration of marriage that it seemed odd that a justice like Justice Kagan, who has never been married, would be so inclined to join it. But the theory is that the court wanted to look unified and be unified. But it is sort of an interesting point, especially considering how many dissents were written on the other side. I think all the justices dissenting wrote their own opinion. So how did we get here this quickly? A gentleman in the audience had asked me right after the Windsor case how long I thought it would take for the Supreme Court to hear this issue. I said 5 years. I believe I might have said 10 years. So in my mind, this happened quickly, rather defensively, if I do say so myself. Justice Kennedy included, in his opinion, a list of all the cases that had decided that there was a fundamental right to marry a same-sex partner. Now, I don't think he included the fact that all those were decided basically as a result of Windsor, his decision, but be that as it may, that's part of the reason why we got here so quickly. So you might wonder, what do states' rights have to do with this? And the answer, to be frank with you, is not a lot. This case wasn't framed that way, it wasn't argued that way, it wasn't discussed that way, and it hasn't been thought about that way. But that doesn't mean that states' rights don't matter. It just wasn't the emphasis of the court's opinion or the thinking on the case. And what about religious liberty? That's guaranteed to be the next fight in this issue. Justice Kennedy gave a nod to it, but certainly not all of the answers. So like I said, there were 4 dissenting opinions. All of the dissents wrote their own opinions. If you look at the opinion in total, 2/3 of it was dissents. And Justice Roberts, I've heard for the first time ever, and now he's 10 years on the bench, read from his dissent. If you're a justice and you're really mad, there are a few ways to express the fact that you're really mad, other than insulting your colleagues. And one of them is to read your dissent from the bench. And very famously, he said, go ahead, same-sex couples, celebrate all you like, but don't celebrate the Constitution. Sort of fighting words. So the question now is polygamy on the table. I would dare say it's not, but that did come up in one of the opinions. And what does this expanded concept of liberty mean? This is where Justice Scalia was like, if I ever sign my name to an opinion that talks about liberty in this way, I'll hide my head in a bag. People have suggested it could mean all sorts of things. My thoughts are it won't mean much, but only time will tell. So some of the controversies that have gone on since then is, there were a couple states saying, hey, we're not going to follow this ruling. Yeah, they are. That's just my thoughts on that. It might have taken a while, but we're all going to follow this whether we like it or not. But the question of whether government employees have to issue marriage licenses if they have a religious objection has received some scrutiny. I think there'll be some court decisions on that. The Americans United for Separation of Church and State has a great document on this that I agree with in most part. I don't agree with everything in it, as does the Texas Attorney General's opinion. But for you who are state legislatures, the question is what's next for you? What can you expect to see coming down the pipe? And basically, there's 2 things. About 18 states have pretty comprehensive protection in the employment and in the housing area for based on sexual orientation. So the majority of our states don't. And what the gay rights community is going to push for is more cohesive, complete laws protecting people on the basis of sexual orientation in housing and in employment. So you can expect to see that. I think you can also expect to see, on the flip side, more state legislation dealing with religious liberty. For example, before all this happened, North Carolina passed a law saying that magistrates and registers of deeds could exempt themselves from same-sex marriage. I think you're going to see things like that and bigger things, like the laws that came out of Arkansas and a couple other states this term, granting people broader religious liberty to object to serving people based on sexual orientation. Whether either of these laws will pass in your state, I think only time will tell. I know on the anti-discrimination front, some federal legislation has been proposed, but that's what you can expect to see coming out of this. Okay, so the second big case was, of course, the Affordable Care Act case. It was a 6-3 decision written by the Chief Justice, joined by Kennedy and the liberals. So for those of you who aren't intimately familiar with this case, the ACA says tax credits are available when insurance is purchased on an exchange established by the state. 34 states had exchanges established by the federal government. So the technical legal question was, is a federal exchange an exchange established by the state? I heard many people speak on this, and I think I can say uncontroversially that most people agreed the text favored the challengers. Does established by the state sound like established by the federal government to you? No, it doesn't. On the other hand, the policy arguments strongly favored the federal government. Would Congress pass a law that would self-explode? Probably not, right? So the court basically said, well, I did hear some laughs in the front. So the court said, those four magic words are ambiguous, but when you look at the act as a whole, they make a little bit more sense. So if credits aren't available on the Federal Exchange, basically death spirals can result. But as I was reading the opinion, as soon as I got to death spirals, I knew it was all over. And Justice Roberts' bottom line was basically this. This is a drafting error. This is a long statute, very complicated. It just wasn't written very artfully. So I attended the oral argument in this case. It was a who's who of who's in Congress. It was a very exciting event. I was really surprised to get in. It was very formal. Supreme Court arguments tend to be, I wouldn't say relaxed, but this one had an air of formality like nothing I'd ever experienced before. I left the argument completely confident that the government would win. And I left that, I think, mostly with just an intuitive feeling and somewhat just, I felt like Justice Kennedy was going to carry the day for the government. I did not. Justice Roberts didn't tip his hand. I didn't have a strong feeling that he would support the act. I wasn't sure, to be honest. So when he sided with the government and he wrote the opinion, I was somewhat surprised. I have what he wrote about the case on the screen. It's really hard to read, but the long and the short of it, it was a very sort of pragmatic analysis, kind of saying, look, Congress probably wouldn't have written a law that would just unravel itself, so here we are. I think there's more to his opinion and more to what he did than pure pragmatism. I think he is a pragmatic individual, but I don't think that's how he defines himself. In the same way that Justice Breyer, for example, pragmatism is sort of the God he worships. This is what I think. I think that at the end of the day, Justice Roberts is the fox. And what do you not do? You don't outfox the fox. And I think he saw this law, or the challenge to the law, as Monday morning quarterbacking to sort of take down a major act. And he didn't like the idea that someone was trying to pull the wool over his eyes. Now, had it been another law and liberals trying to pull the wool over his eyes, would he have been more annoyed? I suggest yes, he would have been more annoyed. But I think that was sort of his bottom line, and I think that was where he was coming from. So in this case, there was only one dissent. It was written by Justice Scalia, and he basically said, as John pointed out, why do we keep on changing the rules for the Affordable Care Act? We might as well just call it SCOTUS care. So the question is this: what's next for the Affordable Care Act? I've heard many people speak on this, and the overriding theme that everyone seems to agree on is this: the ACA is here to stay. There'll be other challenges. There may be other parts of the act that are struck down, but the act is going to fundamentally remain the law in the books unless and until Congress does something about that. Now, with that said, I did some research. It took me about a half a day. I spent way too much time on it. I just sort of got into it. There is a litany of lawsuits under the ACA still happening, coming from a variety of states on a variety of issues. Despite all my preparation on this topic, it is beyond the scope of this presentation to talk about what all of them are. Now, with that said, some of them really do get to the fundamental heart of the ACA. And only time will tell whether those will be successful. But the long and the short of it is, litigation over the ACA is not over, even if the act is, in fact, here to stay. So the third case that I consider a really major case is the Fair Housing Act case. It has a very long title. And the question is whether disparate impact cases may be brought under the Fair Housing Act. For those of you, disparate impact is sort of a legal term of art. It's one thing to sort of intentionally discriminate, to have a policy that is intended to have that effect. It is another thing to have a policy that happens to burden a racial group, a minority group, a group based on gender, more significantly, regardless of intention. And that's what disparate impact claims are all about. Every aspect of this case was interesting. I mean, there was not one, for a Supreme Court term that was high drama, this case took the drama to the very next levels. The court had accepted this issue not one other time, not two other times, but, well, two other times. This is the third time it went before the court. The other times, someone had persuaded the parties to settle. All the federal circuits, and I believe it was 9 out of the 11, that had decided this issue had said these claims were possible. So the court was widely expected to rule the other way. Why else would the court have taken the case? And then, to add to the drama, in the oral argument, Justice Scalia suggested that he believed the claims might be possible. And then he also suggested later on that he wasn't so sure about that. But that garnered a ton of attention. There were only 2 cases this term that involved the use of race. That also made this case significant. It was a 5-4 decision written by Justice Kennedy, decided at the very end of June. So the facts of this case, I don't think affected the outcome of the decision, but what they did affect was, I think, how the opinion was written. Basically, a housing agency or a housing nonprofit sued the Texas Department of Housing, saying, look, you're giving these credits to build affordable housing in too often in majority-minority neighborhoods. You're not giving them often enough in more affluent, more white neighborhoods. And there were some good statistics that indicated this was happening. For example, 92% of the low-income housing credits were located in areas with less than 50% white applicants. Now, what made the case a little bit more complicated was that federal law encourages these credits to be given in lower income areas. So the court, like I said at the beginning of the presentation, how did the court reason this decision? It basically said, look, we've been dealing with the language, similar language in Title VII and other statutes for 40 years. And the language in Title VII and in the Fair Housing Act, it's very similar, and it's been interpreted in these other laws to include disparate impact claims. Then, I think also very significantly, in 1988, Congress amended the Fair Housing Act, and they created some exceptions to disparate impact. Well, creating exceptions to disparate impact means you think disparate impact already exists, right? And then, of course, the court said, disparate impact claims go along with the central purposes of the Fair Housing Act. But if you know anything about Justice Kennedy, you know this. He does not like race-based distinctions. He's willing to live with them. He does not like them. And his decision and his rationale and reasoning reflects that dislike. And I think if there's one thing that keeps Justice Kennedy up at night, it's not how he's voted in the abortion cases or in same-sex marriage. It's racial quotas. He's absolutely terrified of racial quotas. If he ever writes in decisions involving race, he's always talking about how he doesn't want quotas. And that came up in this decision. He basically said, look, it's possible that what's going on in this case is that, the Texas Housing Agency just had to make a difficult policy decision. Should it have more affordable housing in more low-income neighborhoods or higher-income neighborhoods? Maybe that's just a policy decision that the agency should make. And he said, if governments, any housing policy they have that has, his term is necessary to achieve a valid interest should be upheld. And he said, claims that are based exclusively on statistics have to prove that the government's policy caused the specific disparity. And then he said, when remedies are available, there shouldn't be quotas. Again, like I said, Justice Kennedy hates quotas. So the bottom line is, yes, Fair Housing Act claims are possible. Will they be easy to bring and win? No, they won't. And I think he made it pretty clear. But I don't think it's over for them either. I think they just are going to have to be carefully litigated. So Justice Scalia did not write his own dissent in this case. And what was interesting was that both so San Francisco filed an amicus brief saying, look, we think disparate impact claims should be possible. Sometimes local governments actually use disparate impact claims to sue other people. I'll give you an example. Apparently in the housing crisis, or pre the housing crisis, a bunch of companies were giving minorities who qualified for non-variable interest rates. They were giving them the variable interest rates anyway. And of course, those proved to be more problematic after 2008. And so cities like Philadelphia were suing mortgage lenders saying, you caused this blight in our neighborhood. You could have given people a loan that they could now still be paying, but you didn't. So it was interesting to see the majority and the dissent talking about how local governments feel about these claims, because in general they're sued under them, but in some instances they can sue. So now let me first check the time. Oh, I just forgot. I'm stuck on. I'm 3 hours different. So my Fitbit isn't. It's 10:15.
It is
10:15. Okay. Oh, geez. Yeah, my Fitbit doesn't follow the satellites, apparently. Okay, all right. So I've still got a little bit more time. We have to wrap up at 11:15. So I'm going to talk about some of the cases that are big now for state legislatures. Because there are so many big cases, there weren't as many big cases for state legislatures per se. But the most significant case, without a doubt, NCSL filed a brief in this case. Oh, perfect. That's awesome. NCSL filed a brief in this case, and it's the biggest case for state legislatures in their legislative function in the time I've worked at the SLC. And it's the Arizona redistricting case. And the court held, practically speaking, that state legislatures may be excluded entirely from congressional redistricting. And it was a 5-4 decision. It did not go the way I expected based on oral argument, and it was decided on the last day. So I went to the oral argument, and I wrote something. It was on NCSL's blog. And so I told you before how when I went to the ACA decision, I was completely confident the government won. When I wrote an article about that, I did not say that. Because it's such a big case, I didn't want to be wrong. I was more neutral about it. After I went to this oral argument, I wrote an article. Arizona legislature wins. No doubt about it. But here's the thing. The cases that come down on the very last day are usually the most controversial and or the cases that the court has had the most difficulty deciding. You may remember a few terms ago, the court heard an affirmative action case, and they ended up deciding it very narrowly. It was argued in October, decided in June. They were obviously having significant problems with the case. So the fact that this was decided on the very last day led me to believe that they had some problems and that there are possibly some vote changes going on here. So it ended up being a really interesting case. So basically, in 2000, Arizona voters adopted Proposition 16, which said that all federal redistricting authority would go to independent commissions. So then there's the election clause of the Constitution, which says, the time, place, and manner for holding elections will be decided by the states, except that Congress can then trump those regulations. So what this case fundamentally asked was, who is the legislature? Is it the body or is it the people? And Justice Ginsburg's opinion unequivocally said it is the people. It was a celebration of direct democracy in the same way that Justice Kennedy's opinion was a celebration of marriage. So basically the court looked at dictionaries from, many moons ago and said that legislature at the time was defined as the power to make laws. And in Arizona, quite frankly, they have a quite active voter initiative. And the people in Arizona can literally make laws. And this is one example of them. And then the court said, regarding the elections clause, that really has more to do with the fact that Congress can trump what states do than what states can actually do themselves, which wasn't how I was looking at it. But anyway, and I guess the court's last point was sort of a pragmatic one, which is if legislatures can override redistricting commissions, other voter-initiated elections laws could also be in jeopardy. So there were a number of dissents, 3 opinions actually, and what got the most attention in this case was Justice Roberts' use of the word "what chumps," which I have to say it makes me smile to even talk about it right now. So basically, in the 17th Amendment, before the 17th Amendment, it was the senators who legislatures got to choose senators. So the 17th Amendment said, no, the people in the state get to choose senators. And Justice Roberts' point was like, what chumps? Why pass the 17th Amendment when really the legislature is the people? And then, he goes on to say, basically the court's decision was totally reasoned wrong. So what's next for state legislatures coming out of this case? I think in reality, like I said, I'm going to tell you this is the biggest case for state legislatures in the time I've been at the SLC, but for some of you it won't make any difference at all. If you live in the East, for example, there's 1 state, 2 states with voter initiatives. The long and the short of it is this. You, as state legislatures, are very unlikely to say, we're done with congressional redistricting. We're just going to turn this over to a commission and forget it ever happened. We're not going to have anything more to do with it. For something to happen like what happened in Arizona, you'd need a really strong ballot process. Many of you aren't from states that have a really strong ballot process. But for those of you who do have a strong ballot process, this could happen to you. Your voters could take you completely out of this, and it would be constitutional for them to do so. Now, this is what I guess really gave me, I really got a kick out of this. So this is the whole idea behind these redistricting commissions, right? They're supposed to, I see people smiling in the audience because they already know what happens. There's got to be some people from Arizona. So the whole idea behind these commissions is that they take the partisanship out of redistricting, supposedly. Even Justice Ginsburg's majority opinion was like, well, maybe they work, maybe they don't, but that's what they're supposed to do. And I believe the very same day that the court decided this case, it accepted Harris versus Arizona Independent Redistricting Commission. Does that sound familiar to you? Arizona Redistricting Commission. So the challenge in this case is whether Arizona's plan violates one person, one vote. So it seems sort of ironic that on the day they would sort of say this independent commission is the be-all and the end-all, they would accept a case saying that it basically had failed at its task. So that was, I don't know if the irony was certainly not lost on me about that, but, you know, it's such a big day that, you know, most Supreme Court reporters weren't focusing on that thing. But, you know, more on that. So now I'm going to move on to a number of cases that may generate some state legislation / state action. If you have not heard about the North Carolina Dental Board case, this is a great time to get yourself familiar with it because it is a case that's probably going to impact, if not every state, probably most states. Whether you think about it on any given day or not, all of you have hundreds of boards and commissions. I don't know that there's any state that has thousands, but I would be surprised if there was any state that didn't have about 500. So this case has to do with boards and commissions that regulate professions through licenses and rules, which all of your states do. The Supreme Court said this: if a controlling number of state board members are market participants, the board must be actively supervised to be immune from antitrust law. So it's a 6-3 decision, and the long and the short of it is this for you as state legislatures. To comply with this ruling, you have a couple of choices, which I'll talk about later, but you may end up writing some state laws and or having to actively supervise boards and commissions yourself. Okay, so what happened in this case? North Carolina basically the North Carolina Dental Board rid the state of non-dentist teeth whiteners. So per state law, this is really important, per state law, 6 of the 8 people on the commission had to be actively practicing dentists. So you can see why the board was inclined to get rid of non-dentist teeth whiteners in the state, right? So the FTC accuses the board of violating federal antitrust law. And the board says, no, we're immune per the state action doctrine. Well, what's the state action doctrine? Well, let's go back to 1943, but not stay there very long. The court created the state action doctrine, which said that states and state actors are immune from federal antitrust liability. Now, states can grant this immunity to non-state entities if they're being actively supervised and the clear articulation requirement is met. The dissenter said, look, Parker applies in this case. The dental board is essentially the state, right? It's created by the state. It operates on the behalf of the state. It is the state. And the majority of the court said, no, that's not what Parker said at all. The court said, look, this board is a non-sovereign entity, so therefore it has to meet the clear articulation and the active supervision requirements, particularly because it has a majority of non-state or of market participants. So what are you going to do as state legislatures? What are your choices? Some of you, I think, have already complied with this decision or have dealt with it in some way. Some of you probably haven't. You basically have 4 options. One is to look at your boards and reduce the number of market participants on the boards. That may require a change in law, like the North Carolina dental example I gave you. There are disadvantages to this approach. What came up in oral argument again and again was, if you, let's say you have a neuropsychology or a neuroscience board, a neurosurgery board, that's it. You know, you don't want me sitting on your neurosurgery board. I'm a smart person. I shouldn't be licensing neurosurgeons. It's as simple as that. So the alternative then, if you don't want to put people like me on your neurosurgery board, is to actively supervise the board. This will probably require more of a change in practice than in law. The other thing you can always do is forego state action immunity. Boards don't have to have it, but it might be hard to attract people to serve on those boards if they know they can be sued for violating antitrust law. So that's a downside. And then you can just eliminate some of your boards. If there was ever a time to think about, do we really need 750 boards? This might be the time. So I would say it was in May, all of your attorneys general received a letter from a group saying, so what are you folks doing to comply with the North Carolina Dental Board ruling? And so I guess that leads me to the question for you. There's too many of you to actually ask this question to, but you should be asking your state, or you should be asking yourselves what your state is doing to deal with this. I will tell you, at one of my presentations on this about a month ago, I ran into a guy from North Carolina, and what they did was an inventory of all their boards. And some they're actively supervising, some they're removing market participants. They're doing a whole variety of things. And they have a bunch of reports on their website. It is unsurprising that North Carolina would take the lead on this issue. They were the state sued. So if you haven't done anything on this and you want to start thinking about it, there is a resource available, which is the North Carolina plan. And there are other things too. I think a lot of states are getting involved in dealing with this. I think the problem with this is that there's no, clear answer. There's no, ways, if you do X, Y, and Z, it won't necessarily be solved. What is active supervision? When I give presentations, that is the number one question I get. And Justice Kennedy at the end of the opinion sort of says, it's basically more than rubber stamping. It's really looking to see whether you're really looking at the decision that was made and if it makes any sense. Along the short of it, it's not clear what active supervision is. So it's a bit of a hard ruling to comply with, but there's things that you can do to sort of minimize your risk. And I would say that's what you want to do to deal with this ruling. Okay. So another case that will affect at least 8 of you, and I have the states written down on the slide, but if this case has nothing to do with your state, it's such an interesting case because it has such an interesting and sort of rich history. So numerous states have statutes, and even more cities have ordinances that require hotel and motel operators to keep a registry and to allow police to inspect that registry. And the Supreme Court says that these statutes are only okay if police have at least a subpoena to look at these laws. So there are 8 of you that have states that have hotel registry statutes. And if you're not in one of these states, your local governments may have these ordinances. So what's interesting about this practice is these ordinances and laws go back to England in the Middle Ages. The idea was that if you were staying at a hotel, you were at a place of public accommodation. So it was common for you to leave your name. And in the 1800s, this was like Google. People would go in their spare time as a hobby, and they would go and they would review the hotel ordinance or hotel registry to say who had stayed at a local hotel. It was like entertainment. In fact, it wasn't until 1990 that Los Angeles said, we're not going to make these registries available to everyone. We're just going to make them available to the police. Why did Los Angeles do this? I mean, it wasn't for the Googling purpose anymore. It had a different purpose. It was basically to deter crime. A lot of these, they call them parking meter motels. It was a term I wasn't familiar with, but now say all the time and like to snicker. Parking meter motels. A lot of crime happens in them, specifically drug dealing, prostitution, and human trafficking. So here's the idea. If you write your name in the registry, you don't want to do that if you're a criminal. You don't want people to know where your criminal activity is taking place. So you're less inclined to stay in this hotel if you have to write your name down. And the idea was this. When police came to look at those registries, they weren't investigating people. They weren't looking for criminals. They were merely seeing if the records were being kept. Because if the records were being kept, there was no crime deterrent effect, if you will. So this is not your typical Fourth Amendment case, right? Everyone's staying in a hotel, right? And most people are a little weirded out by the idea that a police officer can just come in and look to see without anything more who stayed at the hotel. It's also, I think, not that difficult to imagine a rogue police officer, abusing this. Looking at the registry to solve crime, or looking at the registry for personal reasons. So it's often the case that Fourth Amendment cases go a certain way where the justices can imagine themselves in their shoes. There was one term where there was a strip search case at a prison that was considered not constitutional, but the GPS search of a car without a warrant was considered unconstitutional. And the bottom line is that, a justice could imagine someone sticking a GPS device on his or her car, but can't imagine it being strip searched in prison. This is the same kind of case. I mean, a justice can imagine himself or herself in a hotel. It's just sort of as simple as that. So what the court basically said, this search in this case is an administrative search. It should be done to keep in compliance with record-keeping requirements. So a warrant isn't needed. But there should be some sort of way for a hotel owner to protest, to say, look, you keep on coming here every day. You're basically just harassing me with these requests. So the court said a subpoena is enough, and it's a subpoena that the police officer can write out in his or her car. But the whole problem is this. Okay, let's say the hotel owner isn't keeping the registry. So the police officer gives the subpoena, and of course the hotel owner is going to protest and say, no, I'm challenging this. Meanwhile, he or she will go and fill out the registry, right? So the court said, well, as you issue the subpoena, you need a warrant. And the court said hotels aren't a closely regulated business. And it's kind of funny because, like, the fact that the glass in your hotel is covered in plastic, your plastic glasses are covered in plastic, that's the result of an ordinance or a law or a statute or something. So it's not such a stretch, it didn't seem to me, to say that these are closely regulated industries that the court said they weren't. It was very exciting. The Supreme Court cited to the state and local legal centers amicus brief. I must admit it was in dissent. We had talked about all the local governments. We did a huge search of all the local governments that have these ordinances. They really are very ubiquitous, and Justice Scalia cited to us to that point. I think the thing about this case that is really significant is this is really the question. I don't think this case just affects hotel registry ordinances. There are tons of areas of the law where police can inspect registries for record-keeping requirements. Mobile home parks, pawn shops, junkyards, scrap metal dealers, massage parlors. These are all places where, by statute often, record-keeping is required. So the question is, will subpoenas be required in those instances? My guess is yes. Then there are other records, restaurant records, environmental records, labor records, where police or other code enforcement might also be coming in to look at the records. The question is a subpoena going to be required in that case, or even worse, a warrant? I don't think any of that is clear. The court basically has held there's 4 areas of closely regulated businesses, one of them including junkyards. So for sure no warrant is required in that instance. But I think the other areas, it's kind of all on the table. So I think Patel is one of those cases that may require the rewriting of a number of laws that are not necessarily obvious. The International Municipal Lawyers Association has written a model hotel registry ordinance. If you are from one of these states, you may want to get your hands on that ordinance because you could use it in drafting a new statute. Because it's still possible to, of course, search these registries. You just need to have a subpoena available. So that's that. Okay, so the court decided a death penalty case. One death penalty case this term. Very, very interesting case. I did not attend the oral argument in this case. But I heard a presentation with a Supreme Court reporter who said that it was the most contentious oral argument I think he'd heard. I don't know if it was his whole career or for the Roberts Court. And this is in a term where the ACA was on the table again and same-sex marriage was on the table. He said that what happened in the oral argument was that Justice Sotomayor, and if you know anything about Justice Sotomayor, she talks a lot during oral argument. She's very vocal, very active. She, I guess, dominated the oral argument and accused the attorney from Oklahoma of lying in his briefing. And her questions went on for so long that the Chief Justice granted the attorney from Oklahoma additional time in oral argument. and granted the other side additional time in oral argument. So the case became a very sort of embittered dispute. If it wasn't decided on the last day, it was decided, I think it was decided on the last day. It was 5-4. The bottom line on the case is very, very simple, but the rest of the case is fairly complicated. The bottom line is this. You can use midazolam as a lethal injection drug for a 3-drug as part of your 3-drug protocol if you have the death penalty. But like I said, everything else is complicated. So this is the bottom line. All the states that have the death penalty and the federal government use lethal injection. In Bays versus Reese, the court had approved a 3-drug protocol that began with a sedative, a paralytic agent, and a drug that causes cardiac arrest. The sedative, basically anti-drug penalty people in the United States and in Europe convinced drug manufacturers to stop making that drug. So they were unable to, and stop making another alternative drug that could have been used just as well. So states began using midazolam. You probably remember, I mean, I had no idea the Supreme Court case was going to happen, but you probably remember reading about the botched execution in Oklahoma. It was pretty bad. The guy, I guess he had like slit something, like his hand or something, and I guess that makes it more difficult to insert an IV. And so they thought the IV was inserted, but it wasn't. And he got all 3 drugs, and he was talking, and he was saying things like, you know, this isn't right, something's wrong. And the execution lasted longer than it should have. An investigation was done, and midazolam was used, 100 milligrams. An investigation was done, and basically they concluded that the problem was the IV. It wasn't necessarily the use of midazolam, but still it was ugly and it made the news. And the state went from 100 milligrams to 500 milligrams. So a bunch of prisoners challenged the use of this drug. And they said, you know, look, it's cruel and unusual punishment. So the court disagreed, and it basically said that the prisoners failed to come up with an alternative drug. And you might say, wait a minute. I know you're laughing. I mean, it's on some level it's outrageous. I mean, the idea that you are protesting the drug as cruel and unusual, but you can't win unless you come up with an alternative drug seems sort of outrageous. On the other hand, if you assume that the death penalty is constitutional, there must be some constitutional way to kill you. So, I mean, it's all just, I know, it sounds circular and sort of crazy, but that's how it is. So, then the court went on to say, look, there's no scientific proof that 500 milligrams of midazolam won't render you sufficiently unconscious. But there's no scientific proof that it necessarily will either. But there's no scientific proof that says it won't. And all drugs have a ceiling effect, or like most drugs have a ceiling effect. Midazolam has one. But the court said, look, 500 milligrams, you're just so out of having to worry about that. So this is how the case ended up getting so controversial. Justice Ginsburg and Justice Breyer said they wanted full briefing on whether the death penalty is unconstitutional. That was a jaw-dropper. I mean, it was just huge. Now, 2 things. 1, there are not the votes to overturn the death penalty on this court. I do not believe there are the votes. Justice Kennedy, he's, again, a little wishy-washy on the death penalty. But I do believe he believes in it, or he's okay with it. So in some ways, like, how big of a deal is it? It's hard to say. The other point of intrigue is, why did Justice Kagan and Justice Sotomayor not join their colleagues in this dissent? So this is the reason that I've heard, and it's very, very interesting. So Justice Ginsburg has been on the court since the 80s, and Justice Breyer has been on the court for a really, really long time. In that time, if you're in the Supreme Court, the very last pleas to not be executed go to you. And you have to decide, does this case have merit or doesn't it? And the reality is, we all know, especially in a 30-year period, that numerous people have been put to death who were innocent. And it's possible that the Supreme Court said no to a petition in one of those cases. It's possible in many of them the Supreme Court wasn't petitioned. But the long and the short of it is, as you go on further and further in time as a Supreme Court justice, you see more and more death penalty. And you probably get more and more cynical about it. And the fact that Sotomayor and Kagan are newer to the bench, they haven't been on the death bench as long as the other justices, I think is part of the reason why Justice Ginsburg and Justice Breyer were more likely to speak up. I think the other thing, too, is like, look, they're both getting older. They're both probably thinking about their legacy, and they're thinking about the people who are going to be on the court next and what the court might look like next. And then, this is the other bottom line, too. The two other dissenters said this, and it's very interesting and very much worth focusing on. They basically said, look, if there are no death penalty drugs available to do lethal injection, we believe that the other means, hanging, firing squad, we believe that those are all cruel and unusual. So basically, the states, this is what you're left with. You're left with lethal injection. You can't get the drugs, no more death penalty. And I don't know enough about the market for all these drugs to know whether it's always possible to have one of these drugs. That may be the case. I don't know. But it was interesting to see those justices at least say, look, the drugs run out, the death penalty runs out. So it'll be interesting to see what happens. So another reason why this case was cited as so contentious and so dramatic is this. So supposedly it's called a courtesy fifth vote. If there are 4 justices who want to stay in execution, another justice will just say, okay, fine, I'll just go along with it. Fine, here's my vote. There were about 5 guys in this case, maybe 4 defendants, none of them sympathetic. So the first time it was up before the court, there were 4 votes, and no one would give the 5th courtesy vote, which is very unusual. So someone was executed. Then, a week later, the 5th courtesy vote appears, we don't know from who, and the 3 remaining individuals were not executed. And it was just weird that dynamic sort of happened where the court couldn't even agree in a coherent fashion to take the case. And what if they had ruled the other way? This other guy would have been executed using this method that made his insides burn, at least according to Justice Sotomayor or Justice Kagan. But anyway, it was a very dramatic case. And my legal nerd point on this slide is that it's hard to read. I mean, it's really impossible to read. But you guys kind of are laughing about it. But the death penalty scholars, the anti-death penalty scholars, have been really up in arms about this case, saying, when is it the responsibility of a criminal defendant to come up with an alternative drug to execute them? It had always been the case that an alternative drug was necessary, but the idea that a criminal defendant had to sort of come up with it, I think, was sort of a surprising outcome. So I'm just going to talk about one last case, and then I'm going to wrap up, and we can have a brief question and answer period. Well, actually, we'll have some time for question and answers. 30 minutes, a lot of time, and there's lots of you guys, and there's plenty of microphones. So the last case I'm going to talk about is Walker versus the Sons of Confederate Veterans. And it ended up being, again, a very, very interesting case. The Supreme Court held 5-4 that states may ban images of Confederate flags on their license plates. So this case so interesting for so many reasons. It was 5-4, did not turn out the way I expected, not at all. Also, it turned out to be a case of more pop culture appeal than I thought it would. So, the deal is this. I live and breathe this stuff. So in some ways I have an amazing perspective. In some ways I have no perspective. And so I didn't know how your average American would feel about this case. And my measure is it CNN's #1 story at 4:30 when I'm commuting home? And on the day this case was decided, it was the #1 story on CNN at 4:30. Interestingly, on the day of same-sex marriage, that was the #1 story until they caught that New York escapee prisoner, and then same-sex marriage was never the #1 story again, because then they had to catch his other partner, and so it was what it was. But more to the point, this case happened it was decided right before the shooting in South Carolina involving the Confederate flag. The Supreme Court does not do a great job of being on top of cultural issues, same-sex marriage perhaps being an exception. It's not uncommon. They're hearing a case this term that started literally when I was in high school. That's actually much more typical for the Supreme Court. So for the Supreme Court to be deciding this issue that wasn't the straw that broke the camel's back, but sort of was part of the ball rolling, it's just very, very interesting. And the other thing, too, is if you know anything about the Roberts Court, you know that the Roberts Court loves free speech, loves more speech. The more speech, the merrier. Citizens United is, of course, the best example of this. And this was decidedly a less speech case, where the court said, no, Texas doesn't have to have these Confederate flag license plates. And the other thing is the sign case that I mentioned at the beginning, that is definitely a more speech case. It was decided on the same day. And a lot of people have commented on how odd that sort of seems. The other thing that was interesting is there was a case involving abortion license plates, which arguably is more controversial than the Confederate flag, and the court declined to take that case at the time, but of course they'll have the same sort of outcome. The long and the short of it is this, the whole idea, the court said basically that the license plates are government speech. And there was a case from 2009 involving a city that had a bunch of monuments on it, and a religion called Summum wanted to put their 7 aphorisms, a sign on the park. And the court said, look, cities use speeches as a place to have their own messages, and they can choose to have whatever they want in the park, and they don't have to have, this plaque from an obscure religion. And the court said basically license plates are about the same. They have the government message, they're the government's property, they're the government speech. But think about it. Do you think of your license plate as your license plate, right? I think of my license plate, it's like my license plate number, right? But I also know that the government issued it to me. So it's kind of the case just presented this kind of interesting dilemma. Like, it's the government speech, but it's also like something an individual has. But anyway, the court said, nope, Summum rules the day. Justice Breyer wrote the opinion. He's very pragmatic. He basically said, look, if the government had a recycling program and they had to include anti-recycling speech in speech about their recycling program, how well would that work? Not all that well, right? The government has a right to use its own voice. And if the government doesn't want the Confederate flag on its license plate, so be it. Justice Alito wrote a really interesting decision. He said basically, okay, so on a Monday morning, if you're sitting on a Texas highway and you see someone with a Texas license plate that said, I'd rather be golfing, do you think that's the message of the state of Texas? Do you think that what Texas believes at a Monday morning? Everyone should just rather be golfing? So it was a point well taken. But here's the interesting thing. Justice Alito wrote the majority opinion in Summum. Now he was dissenting in this case, meaning he didn't like the direction it was going. Justice Breyer had written a concurrence in Summum, and he basically said, I don't like labels. I'm just not a label guy. And I don't like this government speech label. I just don't like it. And now, here it is. He's fully embracing this idea of government speech. So it's probably interesting. And Justice Alito also pointed out, look, specialty license plates are a new phenomenon. And why does Texas have them? To make money. Not to really necessarily convey messages. So how are states responding? A number of southern states have, their governors, all the plates are from southern states. All the Confederate flag plates are from southern states. And a bunch of governors have said, look, we want to get rid of the Confederate flag. This is what's sort of interesting. This ties back to sort of the first case, the board case, the dental board case. What's interesting is that, in Texas, it's some sort of obscure board that decides what goes on license plates. It's not the governor. It's not the state legislature. It's this board. Well, now that states have so much more control over what will be on the message, or they know that they do, it's really interesting to see whether state legislatures or governors try to take more authority over what's on those boards. Because I thought it was interesting how it wasn't like Virginia will remove Confederate flag plates. It was the governor suggests Virginia should remove flag plates because the governor doesn't clearly have that authority right now in Virginia. So I think there'll be some reshuffling possibly in states over who has the authority to decide what is on license plates. Now that you know as states, you can have whatever you want on that and you can exclude whatever you want. I have a feeling you might want to have more control over that. So with that, I am happy to take some questions. I had a whole bunch more cases, but, it can't go on forever, right? Oh, you want me to talk about Rodriguez? All right. So I have a request for the Rodriguez case, which unfortunately requires me to use my technology. Okay, this is one of the police cases of the term. The court has an obsession with dogs. I don't know how many dog cases I've heard, or I've talked about in the time I've been here. It's only been 3.5 years, and there was one term where they heard 2 dog cases on Halloween. I mean, you figure it out. But so this is a question about whether a dog sniff conducted after a Fourth Amendment stop or after a completed traffic stop violate the Fourth Amendment. And the court said yes, they do in a 6-3 decision. So basically, a police officer pulls over a guy who's like swerving off the road, and he gets suspicious after asking the guy and his passenger a couple of questions. He goes back to his car, and he writes just a warning, and he issues it, and then he tells them to hold on, and he calls for backup. And it takes about 8 minutes for backup to arrive. And he walks his dog around the car. The dog smells for drugs, and here we are before the Supreme Court. So you might wonder, well, why did he call for backup? He basically said, look, I was outnumbered. There were a couple people in the vehicle, and it was me and my dog. And I didn't want to search the car alone, which sort of made sense. So what's interesting about this case is there was a case before, Illinois versus Caballos, where the court had said if you do a drug sniff during a traffic stop, that's fine. So the question is, well, what if you do the dog sniff after the traffic stop has been completed? And that was the question that the court had to decide in this case. And the bottom line was the court said you can't prolong a traffic stop to do a dog sniff. So any of you have been pulled over, and probably most of us have at least once in our life. You'll notice that the police always ask for registration and license. Doesn't that prolong a traffic stop? Of course it does. But the court said, look, those measures are to make sure you're operating your vehicle legally and safely. A drug sniff has nothing to do with how you're operating a vehicle. It has to do with whether or not you're carrying drugs. So this is the question, I think, about the practical effect of this case. Justice Ginsburg, in her majority opinion, said the critical question is whether it's not when the drug sniff happens. It's whether it elongates the stop. I think that's a bunch of nonsense. And so did Justice Alito. He basically said, you know, any police officer who has any sense at all will now just follow Caballos. They'll do the drug sniff during the traffic search because everyone knows that that's okay. And he ends up saying, you know, I would love to be a fly on the wall on a police officer training course where you just say, follow Caballos and ignore Rodriguez, but don't do the stop after. I think the only thing maybe officers have to worry about as a result of this case, well, there's two things. One, you have to do the drug search while you're doing the drug stop. You can't do it at the end and wait. The other thing, too, is be speedy about it. Because the court said, you know, Justice Ginsburg still said, hey, it can't prolong the stop. So maybe as you're walking up to the car, you walk around the police officer or the car one way. As you're walking back to your car, walk around the other way with your dog. I mean, a place will have to be a little bit creative about it. But I don't think this ultimately like moves the needle on the law that far. Or I don't think it makes the use of drug dogs any less difficult. Now, I do understand that the whole marijuana thing makes the use of drug dogs more difficult. But I don't think this case is going to make the use of drug dogs any more difficult. So, anyway, okay, other questions? 2 microphones, one there and one there. All right, here we go.
Good morning, Lisa. Thank you for your presentation. Had a question with respect to King versus Burwell and the no Chevron deference that you mentioned, and the fact that that's kind of a longstanding principle. And what are your thoughts on that? What, if anything, does that indicate that may be coming down the pike or not?
So that's a great question. Thank you for asking that. So the long and the short of it is, for the lawyers in the room, what happened in the King versus Burwell case was the Obama administration realized, look, we're in trouble with the Affordable Care Act. So what they did was they had the IRS, well, I shouldn't make it sound like it's a conspiracy. The IRS interpreted established by the state to mean the federal government and wrote regulations to that effect. It's very common for courts to defer to agency regulations per the Chevron doctrine. Surprising, I think practically everyone, myself included, was that the court said, look, no Chevron deference. We don't care what the IRS had to say about this. The court said this is basically too important. Congress wouldn't have just left something this significant for the agency to decide. Surprised everyone, certainly surprised me. Not really of interest to sort of the general public, but of interest, the place where Chevron deference sort of makes the most difference in sort of a practical way that affects states, I would say at this point in history, is environmental cases. That's all about the agency interpreting something or other. I can't think of a last time, if ever, that I know of specifically where the court said, look, this is just too important for Chevron deference. Most issues don't rise to the level of the Affordable Care Act, so it'll be hard. It's hard for me to sort of predict how often that conclusion will be drawn. I mean, I think it's something interesting to keep in the back of your mind, but I don't think we're going to see a ton of cases where the court's just going to rely on that in the future. But yeah, it's a totally interesting aspect of the case. Great point. Thanks for bringing that up.
Thank you.
Go ahead.
I have two questions. What do you think the likelihood is of President Obama having a Supreme Court justice as a future career? And number two, I'm interested in what your evaluation is of Clarence Thomas's IQ.
Okay. Okay, so President, well, let me switch the question around a little bit. I was talking with someone else about what's sort of likely for the Supreme Court coming up. Who's going to be on the court next? And this is one of my last slides. I have all the justices' age written down because the point is well taken that at some point we are looking for a future justice. So right now, this is what we have. We have Justice Ginsburg at 82, Justice Kennedy at 79, and Justice Scalia at 79, and Justice Breyer at 76. So I think the long and the short of it is we can expect no retirements in the next year. And the reason is because if someone retired, they would retire at the end of the term, and then very likely the Senate would hold up that nomination. So if anyone was going to retire, like Justice Ginsburg, for example, she would have retired this term or really probably last term. But if we're talking here about an 8-year president, we're talking about 3 justices very, very close to 90. And I would say, like, for all of you, as you think about talking about the presidential election, as you think about voting yourself, this is a critical time for the Supreme Court because, like I said, there's no way an 8-year president wouldn't radically alter the composition of the court. It's as simple as that. So any less controversial questions? Yeah.
15 more minutes if they want.
Come on up.
And no, I won't ask any questions about the future of the court, although it is an intriguing thought about the somewhat intellectual Obama going to the court. So anyway, now my question is about marijuana, which I think was almost literally the last word you said. Do you ever see any challenges coming to the states that are now enacting marijuana legalization laws coming to the court?
Okay, I might need help from someone in the audience because there's someone in the audience I know who knows more about this. There is a dispute right now between a couple of states, Colorado and some of its neighboring states. I don't know which ones. Is there anyone who knows who could just answer? Nebraska. Okay. I don't. It might even be a mandatory jurisdiction case where the court might have to accept it. The long and the short of it is there is a dispute. I suspect the court will at some point have to resolve it. I don't know the specifics of it, but I know it is between 2 states. And, yeah, I mean, the marijuana problem's not going away. It's as simple as that.
Thank you.
You're welcome.
You got 15 minutes. Still want anything? If not, we can wrap it up.
Can I ask another question?
Sure, if it's a real question.
Yeah.
There's interest among some of the political parties in getting 38 states to pass resolutions to hold a constitutional convention as a means to amending the Constitution as opposed to the alternative way mentioned in Article 5. Can you talk to us about the case law or lack thereof regarding that possibility?
Honestly, I'm not very knowledgeable about that. That is a real question. I wish I could answer it, but I'm not the right person to speak to that. I'm sorry.
Hi, good morning. I believe, I don't have the caption, but I believe there's a Texas case the court agreed to hear on redistricting on whether CVAP has to be used or population. Can you just comment on why you think they've decided to hear the case and which way they're going to decide?
I'm so glad you asked. because this is like, I call this case the showstopper. This case just caused like a huge like tidal wave reaction. Okay, so glad you asked. Okay, this case comes out of Texas, and it involves the question of whether total population or total voter population have to be used in redistricting. I didn't know a thing about this case when it first came across my desk. And it took me a while to even understand what's total population versus total voter population. Then I remembered, oh yeah, all those people under age 18. Then, when I got a little bit more sophisticated, undocumented people. Okay, so then I started really seeing what the controversy was. So basically the court had said a while ago, I can't remember the name of the case, more or less that states could choose what they wanted to use. And practically speaking, states, almost all, maybe one or two, don't use total population. Why? Because of the census. Because it's impossible to sort of get accurate total voter population. The people that are even on your voting rolls, that's not accurate voting population. That's just who actually votes. So the only real number you can actually get your hand on that's like an actual number is total population, because that's what the census does. And even that number, of course, has its problems. So this is why this case caused such a controversy. The court has, since maybe the late 80s, turned down multiple petitions with people suggesting that the real criteria should be total voter population. So when the court took the case, people were confounded. And so the long and short is, I don't know why the court took the case. I mean, to me, it seems like, I almost want to say it seems like a loser. Like, why would why not just leave the status quo the way it is? So conventional wisdom is that the court would take a case like this to come to another outcome, to say, no, if states want, and then there's a whole bunch of different possible outcomes. The court could say total voter population is mandatory. The court could say total voter population is mandatory, and here's what it is, because not everyone even agrees what total voter population even is. Or the court could say it's sort of the status quo, like you can use total voter population if you want, or you can just use total population. Or, so there's all these possibilities what the court could say, which makes it sort of harder to predict what the court will do. I haven't the faintest idea why the court took this case. And there isn't a writer out there that I've seen that's been able to commit to a good reason for the court taking the case. Obviously something is up. And the theory is, and this wasn't obvious to me, but it's probably obvious to all of you, is that this, the total population versus the total voter population benefits urban areas because more undocumented people live in rural areas or live in urban areas. I don't know whether that's, that's just sort of the way the case has been presented. But it's absolutely captured the imagination of anyone who cares even the least bit about redistricting. The other thing that I should mention for next term is that this is one of 3 redistricting cases the court has taken. The other 2 are fairly obscure. One was the Harris case I mentioned before, and the other one is, it's something about, I can't even remember. It's a jurisdictional case. It's not even, wasn't significant enough for me to even remember the specifics of it. But it's already turning out to be kind of an odd term because you have the court taking 3 capital punishment cases, a life imprisonment without parole case, and then probably a solitary confinement case, and then 3 redistricting cases. Like, why did the docket come out that way? No one knows. But it's sort of an intriguing aspect of the case. So everyone will be waiting to see what happens there. It's just a really intriguing case.
So long as you mention the life without parole, I guess you're talking about whether Miller v. Alabama should be retroactively applied?
Yes.
I'd be interested in that since so many states seem like they're on a roll now with regard to bringing state laws into compliance with Miller v. Alabama, but without knowing retroactively where the court's going. What do you expect?
Well, I think people were really frustrated by the fact that the court didn't decide the retroactive issue. So the Miller v. Alabama was whether juveniles could be in prison without parole for the rest of their lives. And So, of course, a ton of people were convicted, like in the early 80s and in the 70s at 16 years old, in prison for life without the possibility of parole. The court said nothing about retroactivity, and states have done a variety of things. It's been litigated all over the country. The court took a case this term. It actually settled. The state was just like, fine, just go, and they just let the guy go. It was Louisiana. Then the case came up again. My guess is the court will say it's retroactive. I don't know why I feel that way. I guess because I think they were willing to sort of go so far as to say it was not okay to do that. What's the sense of not making it retroactive? That's sort of just my intuitive response to that. But it's caused a lot of havoc in the states, and it'll be good to see that issue resolved. The other big case of the term accepted so far is the Fisher case. This is an affirmative action case out of the University of Texas. The court has already heard it, so the court will be deciding another issue on it again. And predicted is, like I said, a case involving whether solitary confinement is constitutional. And then there's been a lot of states that have changed abortion laws, made abortion a little bit more difficult to obtain. It's expected the court will take, there's probably 5 or 6 cases with different issues. It's expected the court can run but not hide from abortion, and we'll be taking one of those cases this term. I don't think anyone knows which one. Not really great predictions on that, but that's another thing to sort of look forward to. Got another question? Well, we just had to warm this audience up, you know. You guys have questions?
The Gilbert sign case started out as a church placard type case, but the holding seems to roll in the term political signs. What do you think the status of the law is on political signs?
Okay, that's a great question. So I brought up the Reed case, but I didn't discuss it at length. The city of the town of Gilbert in Arizona had ordinance that said if you have temporary signs, political signs, and ideological signs, they all have different rules. Some can be up for a certain amount of time. Some can be this big. Some can be in the right of way. Some can't. And the court basically said those are content-based distinctions. They said that those you're treating signs differently based on what the content of the sign says. That's unconstitutional. So this is the answer to your question. The court said nothing in the opinion about political signs. Nothing, nada, not one word. But I am not a sign expert, so I have to talk about this case. I've done everything I can to educate myself about this case. And there is a small cadre of sign lawyers who know everything imaginable about sign cases. And I've heard them present multiple times. This is what they say unequivocally and absolutely. Political signs cannot be regulated. We knew that before Gilbert, and we know it now. You cannot have special rules for political signs in your state laws or in city ordinances. Political signs, it's all a free-for-all. That's the long and the short of it. Even though you're right, like Gilbert didn't say anything about it. It said everything and nothing at all. So go ahead.
Thank you very much for your presentation today. I'm a state senator from Indiana. Last year in Indiana we had a huge issue over the passage of a RFRA law. And I just wondered if you have any opinion as to whether or not there will eventually be a test case before, or a case before the Supreme Court which tests the idea of the fundamental rights of religion versus the fundamental right to marriage, etc., and yes, freedom of discrimination based upon sexual gender, etc.
The short answer to your question is yes. I think it's just a matter of time. I mean, those rights, perceived rights, however you want to characterize it, are perceived as colliding here, and you know, it may take a while. The Supreme Court, it's been interesting. Like the Roberts Court has not been as interested in religion as some of the predecessor courts. More interested in race, more interested in other issues. But it's inevitable, like I said, that these issues collide, and that at some point, maybe sooner rather than later, that the court retakes up this issue. You know, RFRA, it's a long story. The court struck it down basically as a federal matter a couple decades ago. It was reinstated in sort of a smaller way. It's a difficult and complicated issue. But as I said earlier in my presentation, Justice Kennedy's opinion alludes to the fact that there are religious liberty interests at stake with same-sex marriage, and like the North Carolina law I mentioned, those issues aren't going away; they're just going to come to a head. That's what I think.
Thank you.
All right, one more question. And depending on how long my rambling answer is.
I'm curious what your thoughts are on the Friedrichs versus California Teachers Association.
Oh, yeah. Okay. So that's another very, very interesting case. So the case involves the question about whether or not a bood should be overruled. So basically, if you are in a union state, you are not required to join the union. But if you do not join the union, you have to pay collective bargaining dues. So the portion of dues that go to everything else you don't have to pay, but it's you have to pay the part that goes to actually bargain the contract. The theory is, look, you benefit from the contract whether you're in the union or not. So a couple terms ago, the court had taken a case out of Illinois that did not directly take on the question of whether a bood should be overruled. But there was a but somehow the issue came to the court's attention. I want to say the parties maybe argued about it. And the court ultimately said, look, we're not going to decide whether or not we're going to overrule a bood. But I think people were surprised by that. My thoughts are, yes, it's going to, yes. I was sort of surprised it came this fast. I do think the court's going to overrule it. Hugely bad for labor. If not so much literally, I don't know how many people actually don't join the union and just pay the, maybe there are a lot, maybe there are a little, but huge symbolic loss for the unions. The court's point would be, look, that theory was never on solid First Amendment grounds, and that in time we've interpreted the First Amendment to sort of go in different directions, and that's really the problem with that decision. A more cynical view is maybe it's a conservative, liberal issue. I would be surprised if a bood lived another day, but I could be wrong, and it will be absolutely a huge case for next term. All right?
We can do one quick one if they got it.
All right.
Oh, no.
This is an easy one.
All right.
Are you for or against televising oral argument at the Supreme Court?
Oh, this is such a controversial issue. And, it's kind of interesting, like, in Washington, this is a really big deal. And I wonder if people in this sort of hinterlands, do people really want to watch oral arguments? I mean, yeah, okay, some people do. All right. Okay, so the argument goes like this. If oral argument is televised, it will become a circus, as if it already isn't, sort of. And the litigants will not say what they necessarily want to say, and the justices won't necessarily say what they want to say. I think, I'm all about preserving the court's, integrity and all that, but I think that's a bunch of nonsense, and I think sort of most other people. I think it's well known that Canada televises their oral arguments. I think it would help people participate more in democracy. I guess I'm all for it, but it's the Chief Justice's call, more or less. He's absolutely against it, and the court would say, like, the fact that they release oral arguments the day of by transcript is the fact that they're in this century. I'm sure many of you would disagree. But yeah, it's a hugely controversial issue in Washington, and I think televised oral arguments would be great. And any opportunity for us to participate in our democracy, I think, is important. And I'm sorry the court doesn't see it that way. So that's it.
Well, before we adjourn to begin the business meeting of the committee, I have to make a quick couple of observations before we thank Lisa again. I've got to tell you, same-sex marriage, the death penalty, solitary confinement, fair housing, Confederate flags, abortion, and teeth whitening, all in the same discussion in the Supreme Court. And finally, for those of you from Arizona, no offense intended, but what's in the water there? You guys love to be before the Supreme Court. So having said that, business members of the committee kind of move to the front here. We're on time. Those of you, let's thank Lisa Thornton again for a great presentation.